Hi everyone, my name is Ori David and you're welcome to the Ori David Consult channel. So today we shall continue with our class on equity, and you will recall that in our last class we examined what the maxims of equity are, what they mean, how they were developed, and what purpose they are to serve. We also examined their reception and application into the Nigerian law. So what we shall be dealing with today is that we shall be taking each maxim one after the other, and we shall consider and interrogate each of them. I must also point out that these maxims have been classified into 12 maxims. So the first maxims that we'll be looking at says what? That equity will not suffer a wrong to be without a remedy. So what this basically means is that equity will not stand by and look at a person that has suffered a wrong and then says, okay, there's no remedy despite the fact that you have suffered a wrong. So equity always makes sure to provide remedies where the common law, where there are no remedies under the common law, or where the remedies under the common law appear to be insufficient. So equity normally steps in. Remember that the essence of a court of equity is to do justice and to achieve fairness and good conscience. So where equity believes that a person has suffered a wrong, equity would try to dive in order to provide a remedy. So in essence, equity will not suffer a wrong to be without a remedy. It's simply saying that equity will not stand by, watch you suffer a wrong, and then not provide you with the remedy. A typical example is that of the beneficiary in a trust. So under the common law, you realize that the beneficiary does not have any interest in the trust. The trustee is seen as the legal owner, and that is it. So there are times that the beneficiary would suffer a wrong, go before the courts, and the courts would actually agree and admit that yes, this beneficiary has suffered wrong, but then they'll say, well, our hands are tied, you don't have an interest that is recognized by the law, and so somebody, the beneficiary that has suffered that wrong, will then go back home disappointed, and if you would remember that later on, people who are whose people who suffered wrongs and had not been remedied under the common law started proceeding to the court of chancery because they felt, what kind of law is that? How is it that the law will look by and see that we've suffered a wrong and then say that we don't have a remedy? So equity started developing some form of succor, so to say, and that is where this particular maxim stems for, to say that equity will not suffer a wrong to be without a remedy. And it is important that I state that in doing this, the court assumed three different jurisdictions. The first is the original jurisdiction. The original jurisdiction is simply that of the beneficiary, like I explained earlier on. So equity was the one that provided an equitable interest for the beneficiary, because equity looked at, okay, fine, you have the trustee being the legal, the holder of the legal interest, but then the beneficiary cannot suffer a wrong, and then you say that the beneficiary cannot bring an action before the court because the beneficiary does not have interest. So equity provided the beneficiary with an equitable interest. An equitable interest is more or less lower than that of a legal interest. So equity assumed that original jurisdiction to provide the beneficiary with that equitable interest, all in the goal of ensuring that equity will not suffer a wrong to be without a remedy. And the second jurisdiction equity assumed is the concurrent jurisdiction. So the concurrent jurisdiction first has to do with equitable remedies. Now, under the common law, the sole remedy provided by common law is damages, pure compensation. So if you go to the common law, and the common law establishes that you have a right that is recognized by the law, and you have suffered a wrong, the best they will do is to award compensation, damages. But you find that there are times that this common law remedy, that is damages, is basically not enough. It's insufficient, in the sense that it is not all the time that compensation would actually compensation will actually serve as a very great or good remedy to an aggrieved party. There are times that somebody that has entered into a contract simply wants to get the agreements done, and not necessarily to get compensated and all. So but then if you should go to the common law will say, well, okay, we award damages. This person does not need to discharge his own obligation. Just okay, pay. What wrong have you suffered? Then the whole thing they have to do to determine the quantum of damages to be awarded and all, the metric and all. They will do that, then they award damages. But then equity started to assume this concurrent jurisdiction alongside the common law to say, okay, well, why you have the common law, the remedy, that is damages, we're going to supplement it with equitable remedies like specific performance and injunctions. So in specific performance, basically what the court is doing is you come before the court, you seek specific performance, and there are some conditions you must also fulfill before the court will grant you specific performance. But once you have been able to fulfill those conditions, the court will grant it to you, not necessarily awarding damages. So what specific performance is simply saying is that the parties are asking the court to force the other party to discharge its own part of the bargain, not necessarily to get compensated. I want to ensure that our agreement, this contract, I want to ensure that it gets done. So that is a specific performance, and also particularly in torts, there are times that damages will not be enough. Still, take for example somebody that is constituting nuisance or thereabout. So you go to the court. Apparently damages will not be enough, because yes, if they should award you damages, you find out that the person might still continue with that particular activity that is a nuisance to you. So you will need injunction for the court to be able to restrain the person from doing so. Injunction is also an equitable remedy. So in terms of these remedies, or in terms of the application and the production, if I may use that word, of this remedy, equity was simply trying to ensure that it does not suffer wrong, that you don't suffer wrong to be without a remedy, and that is in the concurrent jurisdiction. And also I must point out that equity also assumed the auxiliary jurisdiction. So when we speak of the auxiliary jurisdiction, one thing you need to understand is that at common law, discovery of facts that are within the knowledge of the defendant or the plaintiff, or if there are any documents that they are in possession of, the common law could not ordered, they could not be ordered. So under common law, if let's say you have a particular information or you have documents with you, common law cannot give an order for you to basically produce for them, but the court of equity basically says no, and so the court of chancery started ordering parties to make discovery on its oath. So if you have any information with you have any documents in your possession, court of chancery started to do that. And also I need to point out that another part of the auxiliary jurisdiction has to do with the appointment of receiver by way of equitable execution. So what this means is basically that in common law, the common law did not recognize equitable interest. Remember that I said that it was the court of chancery that started to develop this interest and started to dole it out, started to gift parties who necessarily do not have interest interest recognized by the law. So because of that, under the common law, there was nothing like equitable interest. So since the common law did not recognize equitable interest, it then means that a judgment creditor could not levy execution on any property of the judgment debtor in which the judgment debtor had only an equitable interest. So what this means is that under the common law, if the common law should give a judgment in favor of party A, and then says party B should pay party A, remember that the only remedy under the common law is simply damages. So they give a judgment in favor of party A, so meaning party B would pay party A. Party A is the judgment creditor, while party B is the judgment debtor. So under the common law, what we are saying is that if the property that party B has, party B does not have the legal interest, so it is more like it doesn't have any interest under the common law as far as the common law is concerned. But until equity started to provide such a person with equitable interest. So what it means is that under the common law, the party A, that is judgment creditor, cannot levy execution on that property. That is, party A cannot say that, okay, oh, the damages that has been awarded by the court in his favor, that the party B should make payments with it through with that property. So because party B does not have a legal interest on that property. But then equity also assumed this auxiliary jurisdiction to say, oh, so what will now be what will now be the position of party A? If you have given judgment in his favor, he should be paid so amount. But this party B does not even have the money to pay, but he has a property, and then you are saying that party A cannot levy execution on that property. How is it going to get paid? How is it going to get compensated? So which means that A was going to suffer a wrong without a remedy. So you see how even the common law remedy was insufficient. So later on, equity started to assume this auxiliary jurisdiction. So in this regard, equity, a judgment creditor could actually levy execution on equitable interest. So a judgment creditor could levy execution on equitable interest. So let's say the beneficiary is a judgment creditor. Remember that means there is a trust, and the beneficiary will have an equitable interest. So the trust property, which means a judgment creditor can levy execution on the trust property against the beneficiary. So that is what we are talking about. A judgment creditor can levy execution on a property that the owner has an equitable interest, like the beneficiary. And the way the court did it, that is Court of Chancery, the way they did it was to basically appoint a receiver of the equitable interest. So they appoint a receiver of the equitable interest, and that was the way they allowed the judgment creditor to levy execution on the equitable interest, so to say. So, and that is that on the first maxim, that equity will not suffer a wrong to be without a remedy. So we'll proceed to the next maxim, which is that equity follows the law.